Welcome aboard, folks. I'm Stephen Malkowich, your captain on this adventure called Ship of Fools. I'm a fool. Lucky for you, I'm not sailing solo. Join me and a boatload of people, all just trying to make sense of this crazy world. It's a fabulous mess, and you're invited. Thomas Isaac, welcome to Ship of Fools, where wit meets wisdom. Thank you so much for coming out today.
Thank you. Nice to be here.
Thank you so much. I'd like to, Thomas, I'd like you to explain who you are and what you do and your background.
Right.
And we're going to go Reader's Digest because we got a lot of things that we want to unpack here.
I'm a lawyer, and I click. We're done. No. I practice Aboriginal law. I have studied and worked in this area since 1984. This is all I've ever done. I started my career in the public service. Again, apologies for the voice, by the way. I've been talking quite a bit lately.
I can imagine.
In the public service with the government of Saskatchewan, moved up to the Northwest Territories, helped set up Nunavut, and then was hired as chief treaty negotiator by the Clark government in the 90s. And then in, I think it was 2000, I set up sort of Canada's first national Aboriginal Law Group, sort of focused on advising industry and business. And so I've been doing that ever since. And now we very proudly act for public governments, industry and business, and Indigenous governments across Canada. So we're active in every province, every territory. Do a lot of negotiations, do a lot of great commercial work, economic sovereignty, Indigenous and non-Indigenous, and do a lot of litigation.
Okay.
A lot of litigation, and it's increasing across the country. Our team, we have a large team. I've appeared in most of the courts in Canada, and I've written quite a bit, and I think I just came out with my 17th book, co-written with my colleague Grace Wu on Canada and the UN Declaration on Rights of Indigenous Peoples, first book in Canada focused on Canadian law and UNDRIP. And I think it's the first book, somebody told me it was the first book globally that looks at UNDRIP through the lens of a particular country.
Okay.
Yeah.
So, Thomas, the reason that one of the largest reasons that I wanted to have you on this podcast is obviously where wit meets wisdom here, but I wanted you, we've had a land ruling called the Cowichan land ruling that recently, as of 3 or 4 months ago, came out. I want you to delawyer it.
So you're asking a lawyer to delawyer.
I want you to delawyer it. I want you to in terms that people can understand, because I believe that there's a lot of misinformation out there, and me being the dumb Luddite that I am, I think that people that listen to this podcast or watch this would appreciate someone with your background, understanding, being able to, and understanding that it's nothing. There's nothing wrong with saying dumb it down so that we can understand it, and that's the question I'm asking.
Well, so in 2014, the Cowichan Tribe in Vancouver Island made a claim of Aboriginal title over certain lands in the city of Richmond. For your listeners, Aboriginal title is a right to land. It's an Aboriginal right to land. It's not an interest in land. It's the land itself. So if you get title, if you get Aboriginal title, according to the Supreme Court of Canada, which is the highest court in this country, you get the land. So that happened in 2014. A few years later, there was this whole issue, and again, I'll just keep it really simple, of who do we need to give notice to? So there's a claim. It ended up ultimately being a claim for about 1,800 acres within the city of Richmond. And so the question came up, well, do we need to give notice to everyone within the 1,800 acres being claimed, or only to the defendants? And the defendants included the Government of Canada, Government of BC, Airport Authority. Musqueam and Tsawwassen First Nations have a bit of an issue with the Cowichan claiming in their backyard, and the city of Richmond was also a defendant. And the court ruled, no, we don't need to give notice to everyone within the 1,800 acres because the decision won't affect them, essentially. It will only affect the defendants. Okay? Now that's obviously a really important point because I'm about to contradict that point when I get to the decision. The trial lasted just under 520 days. I believe it is the longest trial, civil trial in Canadian history, over 1,800 acres. And that trial wrapped up in 2023. And as you just noted, we got the decision from the British Columbia Supreme Court in August of this year. That decision upheld and affirmed the claim of Aboriginal title over 800 of the 1,800 acres. The judge, and I can go into a lot about the decision. Now we're at the decision. So I've given a bit of history.
Yes.
Now we're at the decision. I'll give you the key points, in my view, out of the decision. So now, on 800 acres, we have Aboriginal title. The folks affected on the 800 acres are not just the defendants. So remember the hearing I had said earlier, there are private homeowners, there are small businesses, and there are large businesses whose private property now has a claim or now has Aboriginal title affirmed on top of it. The judge in the decision said that Aboriginal title is a superior interest to fee simple. When I say fee simple, I mean private property, everybody, or the other legal term, and I like this term, now I'm being a lawyer, but indefeasible title. That's the legal term we use. If you look up the word indefeasible, it means nobody can play around with it. It means that if you've got it, and nobody can take it away from you. What a great title, huh? For something that for so many people's probably the most important legacy asset they have for their entire lives. So the judge says in the decision that Aboriginal title and fee simple title can coexist, and that the Cowichan could seek to obtain those lands. Now, by those lands, I'm now moving beyond the defendants. There was a decision about Canada's lands, City of Richmond's lands, the province's lands. I don't think I'll dwell on those. That's really, I don't think, the headline issue, as important as that is, by the way, to the City of Richmond and others. But it's the effects on all the other people, the private parties that weren't named as defendants and didn't have a right to speak in court. And what the judge there says is that the Cowichan could seek to obtain that land by going to court. There's an 18-month suspension on the effect of the decision. The judge also said something else really critical. And again, I'll try to wind it up, but this is just at a high level. And this is critical. So what I'm about to say is when you get the pen out, or note where this is in the interview, because this is the kicker. The judge could have restricted her reasons to the 800 acres. Now, you and I would probably still be talking based on what I'm about to tell you. But the judge expressly, so there's no debate about this, the judge in 6 different paragraphs, is what I'm about to say, says, oh, by the way, I'm about to tell you something about the interaction between private property and Aboriginal title. And in my view, it's a precedent for the whole province. So anywhere Aboriginal title is proven in British Columbia, this will apply. What did she say? The Land Title Act does not apply to land upon which proven Aboriginal title has been determined. Put another way, if Aboriginal title is declared, the Land Title Act does not apply. Now, final comment on this. If you're a private landowner, that piece of paper you hold. So the judge didn't invalidate everybody's private land. She said, no, you've got your title, but you can't rely on the Land Title Act anymore. Well, the Land Title Act is the title you've got. Without the Land Title Act, you don't really have anything other than a piece of paper with nothing attached to it. And just to give you a sense, Section 23 of the Land Title Act, essentially one of the sections says, if you've got indefeasible title, it's indefeasible against the world, including the Crown, I might add, including government. Now, there's a few exceptions. We all know that as British Columbians, government can expropriate. Yeah. So what that means, Steve, at the end of the day, is that if that decision is upheld, British Columbia, as far as I'm aware, will be the only Western economy on the planet where we don't have the concept of indefeasible title. I assume I don't have to tell your listeners that indefeasible title isn't just about private land ownership. For the people who rent that are happening to listen to this, it is a cornerstone of our economy, period. So the banks rely on private property to be able to issue Visa cards and car loans and Amex cards and so on and so forth. Yeah. It's collateral. So I'll stop there. I mean, that was a lot. There's a lot more to unpack from it, but that was this sort of ultimate statement from the court that I think is why the decision is just getting so much attention that really can't stand. We can't be the only economy on the planet or Western economy on the planet where you don't have indefeasible title that you can take to the bank.
Mm. So that's given it. Now explain UNDRIP. And because this was something that, it was brought up by the United Nations a couple of 3 years ago, 4 years ago, 5 years ago, longer, maybe longer than that. Yes. And that explain that, and then segue into how the courts got so powerful, like in this specific instance. Like
Yeah. So let's start with the UN Declaration of Rights of Indigenous Peoples put forward by the UN General Assembly. It's a non-legally binding document. It is drafted, and this is really, really important. It is drafted as a non-legally binding document. There are some international treaties, I used to study international law, that are designed to be implemented into domestic law. I'll give you an example. The Convention Against Torture. Canada's a signatory. We've actually altered our criminal code. There are reports sent to the United Nations. Why? Because Canada has decided they will adopt the Convention Against Torture, which is a good thing, into Canadian law. UNDRIP is not a legally binding international document. However, and maybe before I move on to the however, what a few Canadian jurisdictions have done, it's not a bad document. My colleague and I just finished writing a book, as I noted earlier. And look, if you're an Indigenous person in parts of Africa or Central or South America, and you're worried about your life, or your family's life, or your friends' lives, because you are Indigenous, or having your lands taken away or exploited with absolutely no say, UNDRIP can be obviously quite a powerful tool. It might be your only tool. Well, I want you to contrast that, Steve, with Canada. And this is something that I don't think a lot of Canadians really understand. And I'll slow my cadence down a little bit here, just to be really clear. The leading country on the globe by a significant margin, you might know where I'm going with this, that protects Indigenous people's rights at law against unilateral state action at the constitutional level is Canada. And we did that in 1982 when we amended the Constitution, and we included in the Constitution Act 1982 Section 35, which says that the existing Aboriginal treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. So we got UNDRIP, non-legally binding instrument, really helpful for Indigenous folks that are having their lands ripped away from them, dealing with possible death, and in some cases death, versus the country, in large part, thanks to our Indigenous peoples, to be very clear, in our court system, that are leading the globe on reconciliation. Our country is leading the globe on how to do this. I don't think that's open for debate. And if somebody wants to debate it, okay, we could argue about whether 1 and 2. I'm not sure who 2 is, but I'll leave it open. But it's not open for debate about our leadership role. So you're then left with, okay, why am I hearing about UNDRIP in Canada? If we're leading the globe, why do I get the sense that some of our politicians have said that we're sort of falling behind the world by not adopting UNDRIP? And it's simply not true. Canada is the light on the hill globally on protecting Indigenous rights and pursuing reconciliation. So then we get to, well, what have some governments done in this country? The Northwest Territories, the federal government, and British Columbia have all enacted statutes. In British Columbia, the acronym we use is DRIPA. Some people have merged. So there's UNDRIP, which is the UN document itself. And then there's the Declaration on Rights of Indigenous Peoples Act, which attaches UNDRIP to it. And it's referred to, or the acronym is DRIPA. So I can tell you what's in that legislation very briefly. There's not much in the legislation. It's fairly brief. But what it says is that governments will do everything possible to ensure that every law, every regulation in British Columbia law is consistent with all of UNDRIP. Well, UNDRIP runs 70 paragraphs and uses, for the most part, completely different language than the tens of thousands of pages we have now in Section 35 that we lead the globe on. And so UNDRIP uses very broad language like the lands that Indigenous peoples either occupied traditionally or currently occupy or have otherwise used are their lands. There's no qualifier. There's no reasonableness. There's no, well, subject to maybe the Constitution of Canada. There's nothing. It's this absolute statement. So what I said when DRIPA was enacted in British Columbia, I think it's 5 or 6 years ago, it was my view that British Columbia was in breach of its own statute upon its enactment, based on the promises set out in it. 2 years, and this is about 5 years ago, give or take, 2 years after that, then Attorney General David Eby brought forward an amendment to our Interpretation Act. And this is all raised in a recent decision. I suspect this is where you're going from the BC Court of Appeal about a week and a half ago. And that amendment in the Interpretation Act says, just in case you didn't get it in the DRIPA Act, every enactment in British Columbia, that means every statute and every regulation under the statute, must be construed in a manner consistent. Now I'm going to add these words, all 70 paragraphs. It doesn't say, it says UNDRIP. But it's really important, I think, that for, again, the non-lawyers to understand, when we say, well, UNDRIP, you go, okay, well, what's that mean? 70 paragraphs. So now imagine me as a lawyer or anybody reading any statute. Now think about the Land Title Act from the Cowichan decision, and imagine a set of glasses with 70 different lenses on it. 70 paragraphs from UNDRIP. So you now have to read the land title statute from the perspective of construing it as being consistent with all 70 paragraphs of UNDRIP. Well, that's impossible.
So, okay.
Sorry, I mean, I know that's a bit overwhelming, right? It's just like, that sounds ridiculous, I'm sure, to most people listening to that, going, that doesn't sound right.
No.
That's what we did, and that's what we sort of promised Indigenous peoples in this province. So that's what our government has promised them.
And now the courts have their with their power. The courts have ruled, okay, and now you have a provincial government who has They've appealed the first ruling, correct?
They have, although we don't have an order yet in the first ruling.
We don't know.
It's going to be some time, but yes, all of the defendants have said they're going to appeal. Yeah.
Okay, so you can't blame the courts, can you?
Look, I'm not a fan of the Cowichan decision. The recent British Columbia Court of Appeal decision on DRIPA, which is an interesting topic, is a good, well-written decision. I'm not suggesting I agree with every word of it, but it's the highest court in this province, and I respect our courts and what they've done. I respect the Cowichan court. As a lawyer, as an officer of the court, I respect it. It's been reported, and you'll see the Trial Lawyers Association of BC last week issued a statement condemning Premier Eby for trying to blame the courts for what I think he referred to as the confusion. And look, again, the Cowichan decision has many, many challenges in it. But we didn't just get to the Cowichan decision. We didn't have robust defenses of private property put forward by the province. Likewise, the Court of Appeal did. I think even if you don't agree with every word of that decision, it's not an unreasonable decision, given the legislation that the legislature passed and the Interpretation Act amendment that then Attorney General Eby put through. And to blame the courts is really a very, very strong view on that. I think it's inappropriate, and I believe it's incorrect. And again, I have a lot of challenges with the Cowichan decision, but if you look at that in a vacuum and not actually understand how we got to the Cowichan decision, we've been dealing with governments in British Columbia that don't want to use their legal toolkit. And then when the courts go, well, there's nothing left for us to do, we have to make decisions. Well, then try to blame the courts when we're not putting forward full defenses. So in my view, full defenses were not put forward in the Cowichan court. And so to then turn around and blame it, and the Trial Lawyers Association came out and I think it was very critical of Premier Eby and him trying to blame our judicial system. And of course, our courts can't defend themselves. And I take the view, Steve, that this squarely lands in our province's lap. And it's not just the Eby government or the Horgan government on UNDRIP. They didn't help. Let's just be really, really clear. I mean, I feel like most recently the government is pouring kerosene on everything, which I don't understand. But this has been building for decades in British Columbia of our provincial government trying to avoid the tough discussion of how we're all going to live together here and settle claims and respect the Constitution.
In essence, every government, provincial government's been kicking the can down the road.
Yes, absolutely, and I'll stand by that answer. In my view, it's not open for debate. We have not had, Steve. So we've got 1/3 of the First Nations in Canada in our province. Now, some might say, well, gee, that's not fair. It isn't, but it's the reality. And most of those, 1/3, so just over 200, the vast majority of them are unsettled. And they all have claims of Aboriginal title. And we only have one province. Land is finite, resources are finite. I don't think it takes the brightest person in the room to go, gee, I wonder what the game plan is. Mm-hmm. I wonder how we're going to settle all these claims.
I want to ask this question, and I come from like in a background in the newspaper business and working in a union environment and having to negotiate labor contracts, and you have to negotiate. Okay, you can't just go. Right. You know, there's and as a young person, starting in this business in 1989, 1990, I figured, I had some cavalier thoughts towards bargaining on the side of management.
Right. Yeah.
As you can imagine.
Yeah, I love it.
In BC.
Yeah. Well,
which really went well.
Yeah. In the early 90s, that would have been perfect timing for you. Yeah, that's good.
It was perfect. I never got to go to the Labor Relations Board ever. I went a lot. the thing is there not an obligation on government's part? And I'll put this note in, insert this note. I wasn't aware that British Columbia did not have treaties signed. I did not know. We
have some treaties signed, but the vast majority.
Is there not an obligation on behalf of the provincial government to negotiate treaties? Is there not?
Yeah, absolutely. And treaties, I'm a big fan of the treaty process because they end up getting constitutionally protected. So, and why that's good. So everyone needs to hear this, as opposed to the reconciliation agreements that are being signed that are just contracts. I mean, they will expire. Parties can walk away from agreements. There might be damages, there might be consequences. You can't walk away from the Constitution. And so I'm a big fan of modern treaty making, and British Columbia was going down that road. But the recent Haida Agreement a couple of years ago, that's not a treaty. That's a contract that then the court where the province ran into court with the government of Canada and the Haida and had a court order affirming Aboriginal title right after the Cowichan decision and before they filed their appeal in August or early September. But treaty making is absolutely the right way to go. It's tough business. It's a lot of work, a lot of resources, but that's how you ultimately achieve reconciliation. It's a very, and Canada has a lot of successes. And again, I'm not an apologist for every treaty. They're not all perfect. I don't like the drafting in some of the modern treaties, but nothing's perfect in our world. But if you ask me, the road is very clear. It has to be treaty making. That's the tool in the toolkit to get certainty and predictability, not these quick, I call it first past the post reconciliation, which just seems to be the mode now. Mm-hmm. We'll pick on 30 or 40 First Nations, give them some contracts. Everybody else can essentially wait. And that's not fair. I mean, that's just not the way we should be rolling.
The reason I'm bringing this up here is that I want to make sure that that anyone that's listening or watching this, the fault does not lie with First Nations. It does not lie with them. It lies with our government and their inability or their failure to, I'll say, to negotiate. Am I wrong?
Well, I would expand that a little bit, Steve. First of all, I agree with you.
Okay.
I agree with you that the only finger to be pointed here is at the provincial government and the federal government, primarily the provincial government, the Aboriginal title issue. Blaming the courts, blaming industry, blaming First Nations, blaming Métis, no. The buck stops at the provincial government. I would say, though, that it's not, I agree with you that negotiations are a key part of it, but it's also putting forward robust legal defenses that are in the public interest. And it's also having robust public policy that's fair, equitable, and transparent for all Indigenous people and non-Indigenous people in BC. And what we see now is the government failing on all three of those fronts. We've got public policy. Nobody seems to know what the public policy is right now in British Columbia. The government does not offer full legal defenses, is afraid. We can give you numerous examples. It wouldn't defend the oil and gas business in the Blueberry River decision. You can't make this up, and the lack of negotiating or focus on negotiating treaties. There are still treaty tables moving, but there are a whole bunch of other tables moving forward that are not treaty protected. And I think we need to get back to focusing on final settlements through constitution protected treaties. Otherwise, this never, ever, ever ends. And I'm not talking about reconciliation. Our relationship with Indigenous peoples in this province is forever. But I'm talking about sort of the business of the business side of reconciliation. We need to start continuing to lock down on treaties, which are a really positive tool for the economy, whether it's an Indigenous economy or a non-Indigenous economy. So I fundamentally agree, though, with your proposition.
And would it be safe, and because I really didn't start to pay attention to this, obviously, until the Cowichan land ruling, because like a normal individual, you don't, until it affects you,
right,
or it could potentially affect you, you don't pay attention. You kind of, and I was aware of UNDRIP. I read a little bit about it, but is it a case? Would it be? Am I wrong in saying that the First Nations, certain First Nations were given an option A and an option B, and option B is better, and of course I'm going to take option B. Would that be a safe comment to make, that, and by option B I mean we're not going to defend, like we're just going to say, okay, here it is. We're not going to, we're just going to sit back and we're going to see how this works out. And I've been told by, certain individuals, just trust the process. Yeah. Well, no, I'm not going to trust the process. And I look at it, and I come from the prairies. Okay. And I come from a background, and I don't know if I told you this, my father worked for the Department of Indian Affairs for 27 years. That doesn't make me an expert on anything.
Right.
But I can tell you this, without this issue being resolved, it creates uncertainty. It creates uncertainty in the market. And that's, and I say in the market, in the province, it creates uncertainty in Canada.
Yes.
Okay. It's not a good thing. And we talked a little bit about accountability, and I got to ask this question. It appears to me that, who's running the show here? It's not the courts. The court's job is to interpret, right? Correct?
It is. I mean, look, some of the decisions aren't the greatest decisions. We got some challenges with some of them, but yeah, they're doing their job of interpreting one sentence that was put in the Constitution with no additional guidance from the folks that put it in the Constitution. That's Section 35. And then we leave it to our judicial branch to try to interpret it. And now we're in a position where the courts are interpreting Section 35, and the province isn't even putting forward robust defenses or the full theory, if I can put it, about I go back to, how is this all supposed to work together? Mm-hmm. I'll put it to you a different way, Steve. If anyone thinks there's a master plan here, there isn't. There's no evidence. I sometimes put it this way. There's no hand on the rudder. There's no rudder. There isn't. And again, I challenge people to bring forward the plan. Tell us and I mean the real game plan. I thought your comment earlier was also just dead on, that about the options, option A, option B. Again, let's be really clear. I'm not going to speak for any particular Indigenous government, First Nation or Métis government, but what I'll say is there's a whole bunch of Indigenous folks and governments in this province that are not being brought along for the ride either. They're not being offered, Haida-like agreements. Mm-hmm. They don't have maybe a mine or a pipeline in their backyard. And this is what I say about the overall game plan. It's not just non-Indigenous people. And by the way, the Cowichan is obviously a big deal right now. And I'm glad the overall issue is getting the attention it's getting. This is the discussion we've been needing in this province for many decades. But also, I hope people understand that there's a whole bunch of Indigenous folks that aren't being brought along for the ride. They're not getting ministers show up in their back door, deputy ministers chartering planes to come in and do the deal with them. Mm-hmm. And if we don't retool and rethink our province and recalibrate of how do we bring along not only all the non-Indigenous people, which we need to bring along in a transparent way, but also all the Indigenous governments. Is it a formidable task? Yes. I think anybody trying to make light of it, and I'm certainly not trying to say this is an easy job, but it must be done. And there, must. I mean, we don't have a choice. And the longer we put this off, the more painful it will be. And we're all experiencing some of this pain now. And, there is a palpable hunger for leadership in this area, not only in our province, but really across the country. Unfortunately, British Columbia is the canary in the mine. I mean, this is where we need the most leadership in the country right now. And we haven't had it for decades in this area. We haven't.
And you can't just blame the NDP.
No.
It's been correct. It's been kicked
correct.
The
I said it, okay, just to be very clear. Now, again, recently, I mean, I would say over the past couple of government regimes, I mean, it's quite shocking to me as a nonpartisan. It's almost like we're deliberately trying to break down our society. I don't understand.
And the thing is,
I really don't understand.
You come from both sides, though. You've represented both sides, like in your practice.
I represent all three sides. I act for industry and business. I act for public governments, and I very proudly act for Indigenous governments. We love acting for our Indigenous friends on economic deals, claims against government, not private parties, but against government. And there is a safe middle in this country where the rule of law exists. That when you look at what the Supreme Court of Canada has written, it's talking about balance constantly in all of its decisions. Of balancing Aboriginal people's rights with the rights of non-Aboriginal peoples. The challenge from the court, though, has been, Steve, that there's over 70 decisions in 35 years on that one sentence, Section 35. So that's 2 decisions a year, okay, from the highest court in the country. And I'm going to say something on it. What I'll tell you, and the court does this in different ways, but every one of those decisions has this principle of balancing. And it also has the principle that it's up to government to do that job, not Indigenous governments. That's not their obligation, not businesses and industry, not private landowners, and certainly not the courts. That job falls on our public governments, whether it's a conservative, liberal, or NDP government, to look out for the public interest, but also make sure it's balanced with the Section 35 rights. And this has been the single biggest issue. This is what keeps my practice so busy across the country. This seems to be an impossible task for many of our public governments, and in British Columbia it has proven to be an impossible task. They almost avoid anything to do with the legal toolkit. Well, they do avoid it, and I don't understand why when those are the only legal tools you've been given.
So where does this leave us now? Like, does this leave us in, what I'm trying to do is wrap my head around, and as I'm sure those that are following this are trying to wrap their head around, where does this leave us? Does this just leave us in the courts fighting it for the next 25 years? What's a plausible solution to this?
But what we need, look, and so you'll hear sometimes the government say, well, the courts are what we want to avoid. We don't, of course. But the courts are our third branch of government. It's okay to have disputes in this country. It's not illegal to have a fight and take it to the courts and have them sort it out. So all this business of we must avoid the courts at all costs, come on. It's not that's not realistic. It's not helpful to reconciliation. Mm-hmm. Think about what I just said. Yeah. If your starting proposition is, we'll never go to court because that's somehow offensive, how can it be offensive when it's a third branch of a democratic government to have, arbiters come in and decide legal disputes? But I wanted to just make that comment before I give you my primary answer, which is, yes, we are in a limbo right now between the Cowichan decision and the Court of Appeals decision on DRIPA. And we're here because of the provincial government in both instances. On the Cowichan decision, we need leadership. For example, the order in Cowichan. So we have the Court of Appeal decision, but we need an order finalized among the parties so we can move it to the appeal. Hasn't been settled yet. Well, it's like 4 months, 5 months. Mm-hmm. why is the government, both the federal and provincial governments, not calling everyone together and asking maybe the Chief Justice, asking the court to hold, for example, a case management conference and settle the order within 30 days. Why? Because we're in an emergency. This is an emergency. So I think we're all in a little bit of purgatory right now, and we've got a direct challenge to our land title system in this province. That's not good. And we've got provincial legislation in DRIPA and the Interpretation Act that is impossible to live up to. And in both instances, we need a strong hand on the rudder. So that squarely, Steve, falls on the provincial government and no one else. The feds can play a role, so I'm not giving them a pass, but fundamentally we need provincial government leadership. We need it today.
Do the feds have the ability to impose that on the provincial government?
Not with respect to provincial legislation generally, and not with respect to our land title system, but they can show leadership. This idea that, well, that's it's the province's land title regime. Well, that's true, but it's the Canadian economy. And the irony is, what I mentioned to you earlier, we've got 1/3 of the First Nations in this country, and the Métis as well. 1/3 of the First Nations, and we have Métis in this province as well. The irony is that in order to achieve the reconciliation that we seek in British Columbia, we need the most vibrant economy in this country. And we're doing the opposite. I mean, people know this. I mean, I talk to people all over the province, and our poor forestry sector. And, we can point, yes, tariffs have been an issue. Yes, the international market's an issue, but make no mistake about it, the provincial policy, those in the no. Mining, oil, gas. We need a disproportionate amount of development in this province compared to any other province or territory. We need it. There's not and I get folks maybe say, well, gee, what does that mean for the environment? Well, I think we can walk and chew gum at the same time. But this business of what we can afford not to develop as much as maybe Ontario does or as Alberta. The opposite is actually true if you're serious about reconciliation, because there's not enough juice in the system to reconcile with all 200 plus First Nations. So we better come to some realistic and optimistic view of our society in this province. And we're certainly not there today.
We talked before we started running, we started going, taping here. At least I believe we did, or it might have been taped, whether or not the provincial government, our premier, is doing this on purpose, or there's some, I'll put the words, is there some sort of Machiavellian plan here that we're so stupid that we can't understand, or does he just not care? Like, and I appreciate that it requires, I'll say conjecture or opinion. It's more opinion, but you got to ask that question.
You do.
You do.
You do have to. I've been doing this a long time. I work in every province and territory. I've worked for all three parties or governments on numerous occasions across the country, and I have no issue working for public governments, whether they're NDP, Liberal, or Conservative. I don't know whether he cares, and I'm not going to suggest that he doesn't. I think that gets more personal than I would ever want to be. But when I look at the evidence, what I see is a palpable lack of leadership generally in this area. And I see deliberate decisions being made that are leading to a breakdown of civil society. in British Columbia and a breakdown of a strong economy. And it's not just Cowichan and not putting forward full defenses, and to hear the lame excuses about what we can't argue, extinguishment by lawyers. There's only two arguments on title. Like once title is proven, you either say, look, it was either extinguished, and look, that could leave open remedies for First Nations still. The courts haven't opined yet about whether or not you can have damages, like financial compensation for extinguished title, or it's justifiably infringed. So this business of, well, we have to pick the right defenses, Steve. There's only two. Mm-hmm. And the third one that the province has tried to argue, displacement, and again, I'll be really clear, is unknown at law. So isn't that peculiar that out of the only three tools you've got in the toolkit, the one you really like is the one that's unknown? At least to me, my textbook on Aboriginal law is going into its 7th edition next year and its 30th year. And I don't know what displacement is. And that's the province's key argument. Look at Blueberry River. This is a case for your listeners, if they don't remember, it's northeastern BC. And it dealt with consultation, a lack of consultation and dealing with the oil and gas sector. And you have to hear me really carefully on this. The province refused to justify the oil and gas sector business. Refused. The court wanted the province to give it arguments on justification of what? 15 to 20% of our economy. The government refused. Now, you ask the question about what's motivating. You look at that and shake your head and go, there's no logical answer to that other than there must be some plan to break things down. Because why would you gamble a large proportion of your economy like that when, in fact, arguing justifiable infringement in that instance is actually helpful to reconciliation? Because now we know that, yes, we have to develop oil and gas in British. It's not a bad thing. I know lots of Indigenous nations that love the oil and gas sector. They also love the environment. Yeah. And they can walk and chew gum at the same time. Why can't our provincial government? So I guess I didn't answer your question, did I? Other than to say it's peculiar. It raises fundamental questions of what's motivating these folks. But we're in this situation that we're in, and make no mistake about it, it is dire. And it's of the province's making. Don't go blaming Indigenous people. Don't go blaming industry. And don't go blaming the courts. And again, we're here because of decades of a lack of attention to a sustainable public policy approach and legal approach in this province. And we've been pouring kerosene on the issue in the past couple of years.
So you paint a dire
Sorry. Jeez, I didn't mean to be so bleak.
But the thing is that it's not that this affects everything.
Yeah.
Like I say this in war. The first thing the conquering nation does is go to the land titles office and burn it to the ground. That's what they do. That's how important the land titles, like title to land is. They destroy that. Okay? That's how important it is. Now that's inconsequential. But that's just a comment. So what is a citizen of British Columbia's recourse? Now, we can scream and holler. I had a conversation with my local MLA, which just I don't even want to talk about that. Yeah. But what is our recourse here?
It's hard for me to give sort of advice on it. The people are dealing with this in their own way. Certainly those people on the 800 acres, my heart breaks for them, and they need to explore all their legal options, including against the Crown. But I would say for sort of the average British Columbian living with all of this is to speak up. I mean, there's not much else here. We need to be speaking up and insisting that we have a sustainable approach going forward and a robust economy. And I said it, we need a robust, we don't talk enough about our economy in this province. I don't understand why, if we're serious about reconciliation, if we're serious about healthcare, education, if we're serious about helping those poor folks down on East Hastings Street in the downtown east side that we seemingly have forgotten about. From all indications that I see, it's just block after block, and the blocks just keep getting more and more. At some point, don't we have to all just say enough is enough? Start governing this province and start doing it transparently with a game plan. So that would be and maybe that's benign advice, I don't know, but we've got to start speaking up. And I don't think we speak up enough. And this is why I'm talking about things like the downtown. You might say, why is he talking about the downtown east side when he's talking about,
because it's all related.
It's all related. I mean, it's appalling that we get used to this as if this is normal, and it's not normal. Having a direct attack on your Land Title Act and not having the province declare an emergency and then say, we will amend the Constitution to protect indefeasible title. They haven't said it publicly yet. That's what a leader would do, in my view. Mm-hmm. I'm not elected, right?
Yeah.
But if I was, I would be absolutely clear with everybody in the province that under no circumstances will British Columbia tolerate an attack on indefeasible title. Why? Because we have an obligation to maintain a robust economy for all British Columbians, Indigenous and non-Indigenous. That wasn't very hard for me to say. I don't know why it's so difficult for people who do that for a living.
Yeah.
I just don't get it.
So in closing, Thomas, what would be a resource? Because I do believe there's a lot of, ignorance breeds hatred.
Yeah.
And the last thing that I want to see is that the last thing you want to see, the last thing anyone wants to see is like finger pointing and saying it's their fault. It's their fault. It's their fault. Looking for the boogeyman. And I hope you can answer this. What would be a resource that our listeners or our viewers could go to, and find out the truth of the facts of this matter here? Because and my background is in the newspaper business, and I can say this, and listen, you know what? They said the same thing about the horse and buggy, automobiles taking over the horse and buggy. But we have different forms of communication. It makes it a lot more difficult to get factual information about this. And that's why I wanted to have you on here to talk to it and say, okay, well, these are the facts. These are the facts. We can have opinions, okay, but these are the facts. Where Thomas, would you find where would you point or direct someone that's looking to become more educated on this and create, form an opinion on it? And then, obviously, and I do agree with you, the only way that we're going to change this is with a groundswell of support of people saying, you know what, enough's enough. Yeah. We can't. So the first question is, what's a resource? Because everybody can't call you.
Yeah, no. And the challenge is we don't have a lot of plain language resources. We don't. Again, I don't mean to be a broken record, but I blame the provincial government for this.
Okay.
When I was chief treaty negotiator in the 90s, the biggest part of that job was public education. I spent at least 50% of my time at local government gatherings, community gatherings, explaining Section 35, explaining why treaty making is a good thing for British Columbia, explaining why reconciliation is a positive thing for the British Columbian economy. We don't do that anymore. It's been years and years. Now everything's done in secret.
No
God forbid we talk to the people that live on Haida Gwaii about acknowledging Aboriginal title on Haida Gwaii. So you go, well, why wouldn't you? right? And so you go through all these things and ask yourself the question. In terms of resources, I will say what's been positive about the Cowichan decision is that I have seen more interest in this area than I've seen in my career. Finally. The challenge is that there's some extremes out there. And I would just say to everyone, and again, everyone will have their own view, political view, but both ends of the spectrum are wrong. Mm-hmm. Okay, I said it. And there's a very healthy middle, and it's a big middle. And, we need more, we need another couple hours to get into the big middle. But Indigenous people have rights. Canada voluntarily amended its constitution back in 1982. Nobody had a gun to our head. And we have rich cultures in this province. And having, vibrant Aboriginal communities and economies is good for every British Columbian. At the same time, we have to have a society where if you're not Indigenous, this is also your province. I'm not a settler. I've got news for everyone. Mm-hmm. I'm not a settler. My house is not on stolen land. It's my land. Yeah. And I also believe in Section 35 rights. Can you imagine? I'm being sarcastic. But this is what I would say to folks, there's a lot of stuff now online. When you start seeing the extremisms of, this is stolen land, or let's not acknowledge Indigenous people's rights at all, that's the scary stuff. But I am pleased with seeing so much on social media, and not that I agree with everything on there. And again, I don't like the extremes on both ends. I think they're both inaccurate. Well, they are inaccurate. Okay? I don't care if it's opinion or not. They are inaccurate on both ends of the extreme. But there's a lot of material now, more than ever. But we do need our provincial government to start educating people in an objective way and not be afraid to talk about what the law is and their role, the public government's role to govern, which they have been very, very hesitant to do up until basically last week, from what I've seen. So that's what I would say to that stuff.
On that note, Thomas, I'd like to wrap it up. I'd like to thank you so much for coming. Thomas Isaac, you are you've written a number. You're a legal scholar on Aboriginal. What would I call it? Aboriginal law, Aboriginal title. You've worked in for all three sides. You don't bring a bias to it, which was important for me to hear. Okay, and I encourage anyone that's listening to this or watching it, to become better educated on it.
Yeah.
And once you become better educated, you understand it. I think that there will be, there has to be, because we can't survive this.
I agree. And thank you for your interest in this area. Sure. It's my pleasure to spend a few minutes with you. And I would also encourage people to do your best to become better educated about what's at stake for this province, and insist, regardless of what political party you vote for. I don't know what I sound like now. I mean, I'm a lawyer, but regardless of what political party you're affiliated with or you want to vote for, start insisting on educated, thoughtful, prudent discussion on these issues with a game plan. Game plan. That's what I would say people need to vote. Regardless of which party, insist on a game plan of how do we get from here to there with still an education system intact, a healthcare system. Maybe we can have some more ferries. Maybe we get better roads and all these things. That's what we've been lacking in the province. And that's what I'd be saying to people.
On that note, Thomas, thank you so much.
All the best. Thank you, Steve. Yeah.
Thank you.
Yeah, that was great.
You may be asking yourself, what's any of this got to do with me? Absolutely nothing. Until next time.